Welcome back to the Truth Hour. Today, we need to talk about the massive constitutional earthquake that just hit the nation. On June 30th, 2026, the United States Supreme Court handed down its ruling in Trump versus Barbara. In a tight 6-3 decision, the court struck down Executive Order 14160, which was signed on January 20th, 2025, by President Trump to end birthright citizenship of children of undocumented and temporary immigrants. The majority, led by Chief Justice John Roberts, affirmed that if you are born on U.S. soil, you are a citizen, period. But while the mainstream media is celebrating or debating immigration, almost no one is looking at the deepest, most uncomfortable truth buried inside the 91-page dissenting opinion written by Justice Clarence Thomas. Today, we strip away the modern political noise. We're going back to the absolute foundation of the 14th Amendment to understand why Clarence Thomas arrived at his decision, and more importantly, why the legal promise of citizenship remains an unfulfilled illusion for so-called Black Americans in 2026. To understand Clarence Thomas's dissent, you have to realize that you cannot correctly think historically about the 14th Amendment without realizing it was never originally built for general immigration. At its very inception, a single devastating legal horror laid at its foundation, the Dred Scott decision. In March 1857, the Supreme Court ruled on Dred Scott versus Sanford. Dred Scott was a so-called black man, a former slave, who sued for his freedom. Chief Justice Roger Taney delivered a ruling that has never actually been formally voted on or overturned by a subsequent Supreme Court panel. Taney infamously declared that so-called black people had no rights to which any so-called white man was bound to respect, and that they could never be citizens under the U.S. Constitution. Fast forward through a bloody civil war, it's July 9, 1868. The 14th Amendment is supposedly officially ratified. Why did it come into being? It came to resolve, to correct, and to legally negate the Dred Scott decision, is what we are told. Because Dred Scott hadn't been overturned by the courts, Congress used the 14th Amendment to force the correction into the text of the Constitution itself. At its birth, the amendment pertained explicitly to enslaved people and the descendants of enslaved people. It was meant to bring them into what I call the constitutional fold. In Trump versus Barbara, Justice Clarence Thomas focused heavily on this exact original intent. Thomas argued that the majority decision to grant sweeping birthright citizenship to temporary visitors or undocumented immigrants actually devalues the very citizenship and Reconstruction era framers built. Thomas' legal argument hinges on the specific concept allegiance and domicile. He noted that the freed slaves after Civil War lived permanently in the U.S., had nowhere else to go, and owed zero allegiance to foreign powers. Therefore, they were fully subject to the jurisdiction of the United States. But Thomas argues that the children of temporary tourists or undocumented foreigners who legally owe allegiance to foreign sovereigns were never textually meant to be included in that automatic 14th Amendment grant. Whether you agree with his politics or not, historically his premise is grounded in the fact that the amendment was custom built for the victims of American slavery, not global immigration. But let's look deeper into the issue. Let's look past Clarence Thomas and past Chief Justice Roberts. There is a massive legal difference between birthright to the land and full citizenship. Being born on the land and being subject to the jurisdiction of the United States is the status quo. It is a geographical accident of birth. But does that status quo give remedy to the trauma of the Dred Scott case? It does not. The 13th and 14th Amendments on paper were supposed to grant citizenship, but in reality, they have never been enough to make so-called Black people full citizens. Why? Because true full citizenship is personified and exemplified by two things: due process and equal justice and protection under the law. To enter into the constitutional fold like all other citizens, a group must have their true identity, their nationality, and their birthrights respected. Instead, the government handed over a piece of paper in 1868 called the 14th Amendment. Isn't it a profound, bitter historical irony? An amendment that was engineered specifically to repair the identity stripping trauma of so-called Black slaves is easily utilized by 6-3 Supreme Court majority to protect modern immigrants. Well, if that were the case, yet now in 2026, the actual descendants of those enslaved people are still waiting for due process, still fighting for equal protection, still experiencing systematic disparities in the justice system, in wealth, and in basic human rights and dignity. During the 2026 arguments, Justice Ketanji Brown Jackson wrote in her concurrence that the 14th Amendment was supposed to be a sweeping anti-caste, anti-insubordination reset for the nation. But as we look at the reality on the ground, that reset button was never fully pushed for the people who've paid for this country in blood. A birthright to the soil is easy to give, but true equal justice, that is a debt America still refused to pay today. And what happened to the piece of paper? It was systematically gutted less than 2 decades after the 14th Amendment was signed. The United States entered into the Jim Crow era, a brutal, legally enforced caste system that lasted from 1870s up until today. If you want to know why the 14th Amendment failed to deliver full citizenship, you have to look at the Supreme Court itself and how it weaponized the law to protect so-called white supremacy. It started in 1883 with the civil rights cases. The Supreme Court ruled that the 14th Amendment only banned government discrimination, not private discrimination. This single ruling gave a legal green light to business owners, hotels, and theaters to slam the door in so-called Black faces. Then came May 18, 1896. The Supreme Court handed down its decision in Plessy versus Ferguson. With that single ruling, the court established a doctrine of separate but equal. The federal government effectively said, yes, you have the right to birthright citizenship under the 14th Amendment, but we're going to legally separate you, your schools, your trains, your water fountains, and your neighborhoods, thus reducing it to pseudo-citizenship at best. Next was the total destruction of the 15th Amendment through state-sanctioned voter suppression. From 1890 to 1910, Southern states rewrote their constitutions to introduce poll taxes, literacy tests, the grandfather clause, poll taxes forcing impoverished descendants of slaves to pay to cast a ballot, literacy tests requiring so-called black citizens to interpret complex constitutional clauses to the satisfaction of so-called white registers, and the grandfather clause, automatically exempting so-called white voters from these tests if their grandfathers had voted before the Civil War. By the turn of the 20th century, so-called black voter registration across the South was wiped out to nearly zero. Even after the overt Jim Crow signs came down, the structural execution of Jim Crow continued through the federal government in 1934. The Federal Housing Administration institutionalized redlining. They drew literal lines on maps around so-called black neighborhoods, refusing to insure mortgages to so-called black families. While the GI Bill of 1944 lifted millions of so-called white World War II veterans into the middle class with free college and cheap home loans, those benefits were deliberately denied to so-called black veterans at a local level. This stripped away the ability of so-called blacks to build and pass down generational wealth. This echoes today in 2026 with recent Supreme Court cases that have further gutted the Voters' Rights Act. So when we look at the Civil Rights Act of 1964 and the Voters' Rights Act of 1965, those weren't extra privileges given to so-called black people. Those were desperate, last-stage attempts to force America to finally respect the 14th Amendment that it had ignored for a century. And that is why here in 2026, the damage of Jim Crow remains fully alive. You cannot strip a people of their identity, block them from the ballot box for a century, deny them the ability to buy homes for generations, and then pretend that a 6-3 Supreme Court ruling on immigration somehow solves the original sin of American citizenship. The true nationality and identity of so-called blacks must be returned, must be acknowledged and recognized. The culture, the divine creed, the religion, all of these must be proclaimed by so-called black people in order for them to even qualify being included into the constitutional fold as all other citizens. Immigrants or others come here, they are required to proclaim their citizenship, their nationality, and their divine creed. So nothing less should be required for so-called black people, the descendants of slaves in this country. The 13th, 14th Amendment were not required to guarantee citizenship or equal rights because the original Constitution of the United States of America already declared all men and women free and equal. Thank you for tuning in to another episode of the Truth Hour. Until next time, stay grounded, keep your head up. Peace and love.